Hi, my name's Chris Mays. I am a partner at Armanino. I head up family office for Armanino nationwide. And today we are talking to Craig Redler. Craig specializes in helping individuals and businesses protect assets from potential legal claims and financial risks. He works with a range of clients from moderate to high net worth individuals, business owners, manufacturers, those with multiple employees, athletes, entertainers, and professionals in high-risk industries such as doctors, lawyers, and CPAs. He also works closely with other financial services professionals such as financial advisors and insurance professionals to make sure every client has a comprehensive estate, tax, and financial plan. Now, a lot of folks do all of that stuff, but what really sets Craig apart is he is probably the only attorney living in the US that has also lived in the Cook Islands, which is one of the hotbeds of activity for asset protection. And so I thought it'd be fun to have him on this podcast and kind of explore all of the different asset protection strategies that he's seen and helped clients with. So with that, Craig, nice to have you here.
I really appreciate you having me. Thank you.
So can you explain what asset protection structures are and why they're important for wealthy individuals?
Yeah, asset protection is just as the name suggests, and you described it really well. It's protecting yourself against potentially ruinous litigation. And like it or don't, we live in the most litigious country on the planet Earth, and litigation is a very real threat to the health and success and continuance of businesses and a real threat to lifestyle. So, without getting too carried away with this, it's a subset of estate planning, where estate planning typically focuses on what happens after a person dies or becomes disabled. Asset protection is more lifetime planning. It more focuses on maintaining your lifestyle while you're working and while you're still healthy and while you're still doing what you do. It's more lifestyle protection planning. It's really another way to look at it.
So like what kinds of events do you set up asset protection structures to protect against?
Well, we live in America. I started my legal career as a defense litigator. So I can tell you from experience, and I'm not telling, I suspect anybody watching this already knows this. When there is a lawsuit, when there's a claim, everybody gets dragged into the claim, anybody with a fingerprint on the transaction. So if you are, and by the way, in the getting sued, you can lose to win. So getting sued is a disruptor, even if you win, and typically is going to not only interfere with other more important things you have to do, but is typically going to cost a defendant money.
Just
So
the time and energy it takes to service even if you have a full legal team, the emotional.
1,000%, and time and energy is a great way to showing up for depositions and hearings and having to produce documents and all these other things.
Well, and the emotional roller coaster.
And absolutely. So the events are anything that can precipitate or cause a lawsuit. You mentioned some of the wheelhouse clients, like manufacturers. Anytime you put something in the stream of commerce, if you own a manufacturing concern, it is a potential products liability case. And anybody in the distribution chain that sells anything to the public is potentially a defendant in any kind of products liability case. So if someone's injured with a defective product, they're going to sue not only the manufacturer, they're going to sue the distributor, they're going to sue the retailer, they're going to sue anybody that's had a fingerprint on this thing, anywhere through the distribution chain. So
if you're a distributor, for instance, like if you're a distributor of, I don't know, fruit or vegetables, and there is a problem somewhere, a consumer consumes this, gets sick, or heaven forbid, dies as a result of consuming this food, you as the business owner, even though you're just distributing somebody else's product, could potentially get dragged into this lawsuit.
1,000%.
Okay.
Not only can you can almost count on it. I mean, but most plaintiffs' attorneys, that's what they do. They'll anybody who touches a transaction is going to get named, because why not? You never know who's going to ultimately be responsible. Who's got deep pockets is another thing they look at, unfortunately.
Don't most manufacturers and distributors have insurance?
Yeah, they do. And again, I would never discourage anyone from getting insurance. Insurance is always going to be your plan A when it comes to asset protection. I would not tell anybody, you've got one of my plans, don't worry about insurance. But insurance, every insurance policy has a limit. They all have top end dollar limits. They all have exclusions. Again, going back to my old defense litigation days, when someone makes a claim, the first thing any insurance company is going to do is look at the claim and try and figure out a way to not pay it. One of the attorneys I used to work with had a joke he used to tell, and at least I hope it was a joke. Said you can buy insurance to protect yourself against someone falling off your roof and hurting themselves, or falling off your roof, but the insurance will exclude them hitting the ground. So it's stuff like that you got to look for in exclusions. Although that's probably an extreme case, I guess.
Yeah. So, okay. So what, I mean, what types of assets can you protect through these protection structures?
Pretty much anything. So what I do as an attorney that practices in this area is I will start by looking at a client's balance sheet and come up with a suggestion or a technique that's applicable to whatever class of assets that client has. So there's certainly not one size fits all plans. For instance, if you are, and most people have a diverse portfolio, but if you have a lot of cash and bankable assets in your security or in your portfolio, I'm going to use one technique. If you have real estate, we're going to use something different. Some of the things and some of the tools and techniques we use to protect cash and securities is not going to work on real estate and or collectible cars or art or things like that. So it really depends on the client's portfolio, but we've got a pretty broad toolbox, and whatever you bring me, I can pretty much put a firewall around it.
But I mean, it seems like cash and securities are easier because you can move those offshore. They're, fungible, where like real estate, it's got a physical location in a country subject to those laws.
Exactly right. That's exactly right. So again, then we'll reverse that and tell you that cash and securities are also low-hanging fruit for creditors. So if I were to sue you tomorrow and I get a judgment against you the day after tomorrow, the first thing I'm going to look for is, do you have any cash? And if you do, and most people have at least some cash or some or securities of some sort. Well, let's just talk about cash. I would ask the court that gave me the judgment, and this is a term that is pretty big in the news these days. What's going on with the ex-president and the judgment that he is facing? I would ask the court for what's called a writ of execution. And I can take that writ of execution to where you bank, and I can give it to the bank. And it's not quite this simple, but it's close to this simple. If I bring my writ of execution into your bank and say I have this judgment against Chris, I need his money, they're going to give it to me. I mean, it's really that simple. But to your point, yes, I can take cash and I can not only wrap it in one of these protective structures, I can physically move it to a place that doesn't have a presence where a court has jurisdiction over it. So it becomes very, very difficult to reach cash. Flip side of that coin is I cannot pick up real estate and move real estate to a foreign jurisdiction or somewhere else where a court doesn't have jurisdiction over it. Every parcel of real estate in the United States sits in a county, and in every county in the United States, there's a circuit court, and every parcel of land is within a couple of miles of a courthouse somewhere, and the judges sitting in those counties have absolute jurisdiction over the real property. So we have to use something more sophisticated than just a simple offshore trust to protect real estate assets.
Yeah, so with the recent passing of the Corporate Transparency Act, has that diminished the effectiveness of asset protection?
Nope, not at all. The structures work because they work. They don't work because we're hiding anything. So this is not burying cash in your
So
backyard.
obscurity is not one of, I mean, I guess like, the last 2 decades, having dealt with wealthy individuals, like obscurity's always been part of the playbook. But it seems like with the Corporate Transparency Act, that's been reduced.
When I first started in this business 15 years ago, that was something we were selling: privacy and security. You can do these things anonymously, and God, probably starting about 2014 when FATCA came out, the Foreign Account Tax Compliance Act, we stopped promoting that as even a feature. Privacy is pretty much dead. It doesn't matter where you go, what you do. Having said that, some of these structures are more private than I shouldn't say some. Most of them are going to offer a little privacy and certainly give you some more privacy than you'd have if you do nothing. The flip side of that coin, that is not why the structures work. If I did a plan for you, you could take your plan, you could publish it on Facebook. It's not going to help a creditor access your assets.
Okay. So how do asset protection structures, I mean, you touched on it a little bit, but how do they differ from traditional estate planning methods?
It's a great question, and I get this question a lot. Foundational estate planning it starts with, most people are looking for probate avoidance.
Right.
And going back to the beginning of my career when I first started doing this, the conversations always started with, hey, attorney, got your name from so-and-so and I need a will. And you talk to the client for a minute, and most people can benefit from something more robust than a will. And now you're talking about what's commonly used in the United States is what's called a revocable living trust.
Yeah.
And we're one of the few countries that recognizes those as even a trust, but that's neither here nor there. But the question I used to get when I was doing a lot of revocable living trusts, and they were very useful. In revocable living trusts, everybody needs some kind of estate planning. And for most people, if you own any kind of property and do have beneficiaries that you care about at all, you probably could benefit from having a revocable living trust. All that's going to do for you is it's going to help the family avoid probate. And I don't want to get too far off course here, but there is value in avoiding probate. Probate is a long and expensive process. And then talk about probate if you want, or on another call. But and then the other thing that these revocable living trusts are extraordinarily useful is in a disability context. People always think about, all right, what happens after I die? Most people are not thinking about, all right, I'm not dead, but I'm in a coma. I can't sign my name. I can't make a decision for myself. Tell you right here, right now, it is easier to die from a legal point of view than being in one of those prolonged disabled states.
Yeah, because the living trust organizes all those authorities and delegates that.
It allows the family to carry on without state or court intervention. So they're very useful. But those plans offer nothing in the way of estate or asset protection. So if I were to sue you and I come to you to take your assets, and you say, well, these assets don't belong to me, they belong to a revocable living trust, that is going to get you nowhere in 50 of the 50 states.
But a lot of our clients, though, have, they have irrevocable trusts, right? So generation one leaves money to generation two, and it's in a revocable trust. And a lot of times we'll see there's creditor protections in there. So while they're a beneficiary, they don't have any rights to withdraw money and all these kinds of things. Are those, I mean, in a certain context, those are asset protection structures, right?
They are certainly better than revocable living trusts. If they are written properly, they can be fairly robust asset protection tools. There are 31, well, the question becomes as to the person that created the trust. If it is a self-settled trust, that is, if you create the trust and you make yourself a beneficiary,
right?
It is in 31 states that will not be an asset protection vehicle. In 19 states, it will. So I'm talking to you from California right now. California, it is not an asset protection vehicle. The statutes in California straight up say a self-settled trust, even an irrevocable spendthrift trust, does not protect the assets from the settlor's creditors. I'm also licensed in the states of Missouri and Illinois. In the state of Illinois, it is the same as California. They do not recognize that trust as an asset protection vehicle. In the state of Missouri, they do. If the trust is not set up specifically for asset protection, and depending on where you do it, depending on the jurisdiction, Another issue is going to be fraudulent and voidable transfers. So the various states have various look back periods to where if you settle the trust within X amount of time from the claim giving rise, even in a state like Missouri or a state like the common states, the domestic jurisdictions where this kind of planning is popular is typically going to be Nevada, South Dakota, Wyoming,
Right.
Alaska, Delaware. Those are the top tier trust states.
Yeah.
And even in the top tier trust states, they've got this look back period. Some are worse than others. Here in California, if the trust was set up, even if it's not self-settled, so make that distinction here again. So in California, a self-settled trust will never be an asset protection vehicle, but a not self-settled trust could be. California, depending on the circumstances behind the claim, if you set up a trust today and you commit a tort tomorrow, theoretically, the creditor can still access the assets you put into the trust. Places like the Cook Islands that you mentioned earlier that really have, and you mentioned I worked there, and why the Cook Islands. Cook Islands has the absolute best statutes on the planet Earth for this sort of thing. But in the Cook Islands, they have what they call the deeming provisions of their statutes. It's the International Trust Act of 1984 is kind of the bread and butter statute there. And the deeming statutes in the Cook Islands say straight up, if a trust is settled prior to an event giving rise to a claim, there is no voidable transfer. So that's why picking the right forum is important. So going back to your original question, the trusts might be an asset protection vehicle. If they're not specifically designed to be, they're probably not as good as they can be. Does that make sense?
Okay. So I guess then, are there levels of asset protection? I mean, when you say, hey, we need the Cook Islands, when you say, hey, we can use one of the common state trust friendly states, I mean, how do you make that distinction?
Well, the first thing, there are levels, and the first level is always going to be exemptions, and we haven't even really talked about that. So every state has property that is statutes that provide for exempt property. And the different states have different exemptions, and some are good and some are not so good. For instance, Texas and Florida have an unlimited homestead exemption.
That's right. That's right.
We always value of your personal residence is protected from creditors, period, full stop. Doesn't matter how much equity you have in the home. Here in California,
I mean, hold on. That only if you've used that house as a security for a mortgage, the lender can still come after that home.
That's another, deploying debt is another technique that we'll use and we'll look at. So yeah, if you have a house with no equity, then certainly it's not going to be a very attractive asset for a creditor. You and I are neighbors. We live on the same street. We do not live in Texas or Florida or another state where you have an unlimited homestead exemption. We both live in $1 million homes. Yours is paid for. Mine, I owe $900,000 on. If you get sued, your $1 million of equity is a pretty attractive target for a creditor. Right. If I get sued, my $100,000 in equity on $1 million house is not much of an incentive at all, because the expenses associated with foreclosing and having a sale are going to eat up any possible.
The $100,000 worth of equity in this example. Yeah, fair.
But I will always look to whatever state the client's in, what their exemptions are, and make sure that we're fully utilizing whatever exemptions are available to the client. And then on to looking at each asset and making a determination what's the best recommendation for that class of assets.
So can you put domestic U.S. real estate in a Cook Island trust?
You can. It doesn't do you a lot of good, quite frankly.
Okay.
Again, to the point that the real estate, if my real estate's a mile from the courthouse and someone gets a judgment against me in that courthouse and they want to come and execute against my real estate, the court's going to, especially like in a state where I'm like in California, and I say, well, wait a minute, judge, that property's not mine. It belongs to this Cook Island trust. And under their law, judge is going to stop me and go, I don't care about Cook Island law. I absolutely positively will permit this plaintiff or this judgment creditor to foreclose on the house. And there really is not much you can do about it. So for real estate, again, depending on the state it's in, we'll probably use different techniques to protect real estate.
Okay. But for cash and securities, then the Cook Islands is probably the gold standard.
Absolutely. For marketable securities, for liquid nothing better. If you are using a Cook Island trust that owns an account at an institution that does not have a U.S. presence, it is extraordinarily difficult for a
Okay.
creditor to access it. I can run you through those steps, and you'll see how hard it is.
Well, let's do that. Let's just so we understand kind of the basic structure of what that looks like. That I think that would be helpful.
The Cook Island International Trust Act, the bread and butter statute there, basically says that no court in the Cook Islands can pay any attention to any process from any other jurisdiction. So they give absolutely zero weight and consideration to foreign judgments or foreign anything for that matter if you're trying to do discovery out there. So the only practical way to attack a Cook Island trust is by some allegation of fraudulent transfer, avoidable transfer. And again, fraudulent transfer, let me circle back and talk about that for a minute. Fraudulent transfer is typically defined, no matter what jurisdiction you're in, as relocating or retitling an asset specifically to avoid a creditor.
Yeah, right.
So again, different jurisdictions broaden and narrow that jurisdiction, but at the end of the day, that's kind of the basic definition. So the only way to attack a Cook Island trust is to be able to establish that the structure was set up to defraud you. And let me get on this you thing for a minute. Places like California and in most jurisdictions, even the top tier jurisdictions in the state, fraudulent transfer can be the structure was set up to avoid a claim, period. Okay, so I set up this structure just with the thought that I just want to make sure I'm protecting myself generally. You can still get caught up in this fraudulent transfer net. The Cook Islands, the standard is that it has to be set up to defraud the specific creditor standing there telling the court that they should disregard the trust for fraudulent transfer. Also, it has to be done de novo in the Cook Islands. So the only place you can make this argument is there.
In their court?
In their courts, correct.
Okay.
And you have an extremely small time window to do it.
So you have there's a proximity, right? A proximity to like when you set up this trust to the event. And then it would have had to have been set up for that event, for that specific individual, and then the claimant would actually have to show up in court in the Cook Islands.
It gets better. All right, so here's the process, right? First of all, under those deeming statutes I mentioned earlier, if you set up the structure prior to the event giving rise to the claim, period, no, you're safe. There is no fraudulent transfer, period. The timeframes are this: you have 1 year from the event giving rise to the claim to have it heard in a court of competent, to file it in a court of competent jurisdiction. So if I commit a tort today, in 1 year and 1 day from today, the plaintiff hasn't sued me yet, it's not fraudulent. All right. So let's say that I commit a tort today, the plaintiff sues me in that 1 year time frame. They have to bring a judgment back within 2 years of the date giving rise. So no matter what, within 2 years of the event giving rise to the claim, I'm safe from any allegations of fraudulent transfer in the Cook Island. So let's say someone hits those extremely hard to hit dates, and I will tell anybody who I don't have to tell anybody who's ever been involved in litigation, getting a judgment in a 2 year time frame. If I commit a tort today and you sue me tomorrow, the likelihood that you're holding a judgment in 2 years is pretty small. But let's say that happens.
Well, the defendant's ability to stall a judgment is pretty good too. So
yeah. So you got your judgment, and now you got to go all the way out to the Cook Islands, which, by the way, is not an easy place to get. There used to be a direct flight out there from Los Angeles once a week during the pandemic. That flight was canceled. Now the only flight from the United States to the Cook Island is from Honolulu. So you got to either fly to Honolulu down to the Cooks, or you got to fly to New Zealand or Australia or Guam and back. So you're looking at the better part of 24 hours just to get there, no matter where you're coming from.
Right.
You have to go to the Cook Islands, or you can hire an attorney. And I will tell you, most of the attorneys on the island, and there's some good ones, are going to be conflicted with most of the fiduciaries there. So it's going to be the fiduciary is going to be a party. So typically you're going to have to get an attorney off the island. So where do people go? The closest jurisdiction that has a similar legal system is going to be New Zealand. So you're going to have to hire an attorney from New Zealand, okay? And New Zealand lawyers, by the way, are prohibited from working on any kind of contingency fee. So you're going to have to pay them a large retainer. So you're going to give an attorney in New Zealand a big retainer to essentially go take a tropical vacation. Cook Islands are beautiful, by the way. If you're looking for a fun place to vacation where your friends have never been, highly recommend. But that aside, you're going to pay an attorney in New Zealand a big retainer to go take a tropical vacation if you can hit these time windows. And once he or she gets there, they have to prove, and the standard, by the way, the standard they have to hit is beyond reasonable doubt, which is the highest legal standard. That is the standard we use for criminal cases here in the USA. Okay. So they have to prove beyond reasonable doubt within these short time frames that the structure was set up specifically to defraud their client, this one creditor. So how on earth are you ever going to even do that? You really need a smoking gun. Boy, I hit Chris with my car. I know he's going to sue me and I'll show him. I'm going to set up this structure so I never have to pay him. You're never going to get that out of me. I mean, maybe I send an email to somebody and it's just, it's certainly very unlikely.
Very unlikely.
So that's what would have to happen to kind of bust one of these. And I've been involved in this industry for a long time, and a good portion of it as a fiduciary. So I've seen it as a practitioner here in the States.
Right.
And I've seen it as general counsel for a couple of the trust companies over there. And I've never seen it successfully done.
Oh, so you've never seen any Cook Island structure broken?
I have not.
Okay. Interesting. Okay. And how long were you in the Cook Islands?
Was in the Cook Islands for about 2 years, and then the company I was with actually moved a lot of their administration over to New Zealand. So I actually moved over to New Zealand and opened an office for the company I started with. It was called Southpack Trust, and I went and opened an office with Southpack in Tauranga, New Zealand, and was there a couple of years, all in about 5 years.
Okay. But that's a long time frame with the sheer volume of Cook Island Trust.
I moved to Auckland a little bit after that and stayed in the offshore space, but not so much with American and Cook Island. But then I came back here to the States and have been doing, from the practitioner point of view here in the States for the last 7.
So this is, and well, I want to go back to one point you made earlier, which was you need to use an offshore, a institution that doesn't have any U.S. presence. What's the significance there?
Okay, well, basically they've got the control, they've got the purse strings.
Okay.
So with a trust, and the way a trust works is you've got 3 parties. You've got the settlor, the person that creates the trust. You've got the beneficiaries. These are the people that benefit from the trust property. And a lot of times it's self-settled trust. Settlor and the beneficiary is often going to be the same person. And then you have a trustee. The trustee is the person that manages and controls the property held in trust. So you need a trustee in the context of any trust. For these particular trusts under Cook Island law, it needs to be someone that is located there. And so you need to hire a trust company in the Cook Islands. And beyond the fact that you want to avail yourself to the benefits of the International Trust Act, what's more important about using a Cook Island trustee is, here's the context. Say we do the exact same trust and you're here in California. All right, I've got a California trustee. So not only do I not have the International Trust Act, but that aside, that trustee is always going to be subject to the order of a court here in California.
Right.
So let's say you use a Nevada trustee. So under Nevada law, Nevada says that these self-settled spendthrift trusts are asset protection vehicles, okay? So I'm here in California and I set up a trust over in Nevada because I want to take advantage of Nevada law. So I commit a tort here in California. Say I have a car accident with another Californian. All right, so that person turns around and sues me in a California court and they get a judgment against me. All right, I can tell you, first of all, if I'm in an American bank, if I'm in, say, Bank of America or Wells Fargo or any national bank, if you ask your California judge for a writ of execution and you walk into any branch of, say, Bank of America and say, Craig's got an account here, I have this judgment against him, I want my money. Well, B of A they're gonna roll over. They're not going to stick their neck out 1 inch.
Even if it's in the name of the trust.
Correct. So that's my argument, though. So I would B of A is looking at a court order saying, Bank of America, the judge, order you to do X, Y, Z. They're going to do what they're ordered. They're not going to put themselves out for me.
Okay.
So I do have an opportunity to go to that judge and file what's called a motion to quash. And I can say, Judge, you should quash that writ of execution you entered because that money is not mine. It belongs to someone else. Well, the judge is going to naturally ask me, okay, well, who does it belong to? So it belongs to, now if I say that money belonged to you, Chris, they'd say, all right, Chris isn't Craig, Craig isn't Chris, I win that. But if I say it belongs to the XYZ trust, court's going to ask me again, all right, so who set up the XYZ trust? I did. Who's the beneficiary of the XYZ trust? I am. I'm going to lose that argument. California judge, 100 out of 100.
Okay.
So say we've got the same account owned by a Nevada trust, or say scratch that. Same argument. The Nevada trust, California trustee, it doesn't matter. B of A is going to roll. California judge is going to let them. So say I use a Nevada state chartered bank. So now it's not a national bank. It's a bank that's only chartered in the state of Nevada, subject to Nevada law, owned by a Nevada trust. Well, I've got a better shot there, but here's the sequence. Plaintiff gets a judgment against me in California. They, under the full faith and credit clause of the Constitution that says every state needs to recognize the act of all the other states, they're going to take that judgment they got against me in California, they're going to take it over to Nevada, and they're going to register what's called registering a foreign judgment. They're going to go to a Nevada court and say, hey, Nevada court, I have this California judgment. Will you please register this? The Nevada court will authenticate the judgment, and then they will register it. And now it is, for all intents and purposes, a Nevada judgment. Gonna walk that they're going to ask the court for writ of execution. They're going to take it to the Nevada bank. Same thing, even though it's a Nevada bank.
Right.
They're going to roll. I got to go to the Nevada judge now and file my writ of
my
motion to quash. And I'm going to say, Judge, you should quash that writ of execution. Under Nevada law, I'm solid. If I'm a Nevada citizen, court will probably give me what I'm asking for. But the judge in Nevada is going to look at it, and they're going to do what's called a conflict of laws analysis. So that happens in our system where you've got 50 states. What state law is going to control? So under my facts, the Nevada judge is going to look at the facts and go, you're a Californian, you committed a tort in California. The plaintiff's a Californian. Presumably the assets in the trust were California derived. The only nexus you all have to Nevada, this whole transaction has to Nevada, is Craig, you decided you'd set up a trust here. And I suspect under those facts, the Nevada judge is going to apply California law and I
Right. Okay?
You're in the Cook Islands. First of all, you are never, ever going to be able to walk into a bank. And by the way, most of the banks we use are not going to be in the Cook Islands, although there's at least one private
I'd like to
bank.
drill into that. I mean, continue with your point, but I want to explore that because I mean, I kind of conflated the concept of a trustee and the financial institution, but I'd like to tease that apart as well.
So say I've got a Swiss bank account or a bank in Singapore or Hong Kong that's owned, the account's owned by the trust.
Right.
And you're never going to be able to walk into a Swiss bank with an American rate. They're just not.
It won't work.
If you were, these Swiss banks are very literal.
And you wouldn't be able to get
it'd be really hard. And then the Swiss bank, unlike the American banks, would probably push back. You're not seeking to get money out of an account owned by this defendant.
Right.
So you're never going to be able to file the writ. You're never going to be able to compel the foreign bank, or more importantly, the Cook Island trustee to do anything. And that's the other thing. Even if you had a bank that would play along, now you can actually, an American judge can make an American trustee do whatever he or she wants, typically, within reason. The Cook Island trustee, not only is it very difficult for an American court to physically file anything or serve them with anything or any kind of due process against them for various reasons. They don't have personal jurisdiction. They don't have, I mean, the Cook Island statutes straight up and say, we ignore American or foreign process.
Right.
So straight up, the Cook Island trustee will never, ever be subject.
So like Malta or some of the other tax, they don't have, like, if you try to set up a similar structure in Cayman, for instance, you're not able to get the same level of asset protection.
That's fair. There are other jurisdictions that hold themselves out as asset protection, and there are some good ones. Nevis comes to mind. I would say Nevis is right there with the Cook Islands in terms of the effectiveness of their statute.
Oh, really?
Yeah, no. So Nevis is my plan B typically, and sometimes I'll do interjurisdictional structures that'll use like a Nevis underlying entity, like a Nevis LLC owned by a Cook Island Trust or something like that.
Okay.
So there are some good jurisdictions. There are none better than the Cook Islands. So
Okay. Okay. So, oh, okay. So Nevis, now why is Nevis plan B? It's just not quite as good as the Cook Islands, or
no, wait, they haven't been doing it as long. I don't think the competence of, with all due respect to Nevis, of the courts down there. There's something interesting about the Cook Islands too. It is so small. It's less than 20,000 people total live there. There's a diaspora. There's probably 60,000 Cook Islanders in Australia, New Zealand, Canada, and here.
yeah,
But,
yeah,
but they all leave. But it's very small. And when they got their they're an independent country. They got their independence from New Zealand in 1965. And when they set up their constitution in 65, they realized that it's so small that nobody's ever going to be able to get a fair shake out of a Cook Island judge. You're going to walk into court, and the judge is always going to be one of the litigants' uncle or cousin or something like that. So they realized that early on. So it's written right into their constitution that Cook Islanders cannot be judges. So where does the Cook Island court get its judges? Well, they again go to the nearest legal system, and it's typically New Zealand. So New Zealand's got a mandatory judicial retirement age, 63, 64, so I don't know exactly what it is, but it's pretty young. So if you're a 64-year-old New Zealand judge, here is the offer the Cook Islands can make you. Your Honor, how would you like to, I know you got kicked off the bench and you probably didn't want to
yeah.
go. How would you like to put the robe back on, wear a wig? They actually wear wigs over there. And come back and do a circuit here in the Cook Islands. So we're going to offer you your a good salary, a paid for tropical vacation at the expense of the Cook Island government, and put you back on the bench. And probably not much of a stretch to say that that's a very desirable position. And the Cook Island, or I'm sorry, the New Zealand judges will clamor to get that invitation. So the Cook Islands really has its pick of the best of retired judges.
Okay.
So they have an extremely competent judiciary.
Wow.
Like, I mean, it's a very, like some of the best in the world.
Okay.
Great accountants and great support professionals all over. The lawyers there, like I mentioned earlier, are typically very good. They're from all over the world. It's just a really good, solid place to do business. All of the laws are written in English. English is their primary language. They do speak Maori, but they conduct all their business in English. The government's very stable. It's parliamentary style democracy. It's the court system is common law. It'd be familiar to any American lawyer, certainly lawyers in the UK and Commonwealth. There's no rebels up in the hills trying to throw the government over or anything like that. I mean, it's just Nevis is good. The Cook Islands is better. The other thing about Nevis is I get the impression that they're kind of bowing a little bit to some external pressure. The Cook Islands has done a little better job, in my opinion, at kind of pushing back on that.
Right. So, but the financial institution that holds the securities would not. So you could use like a Swiss bank, or you could use anywhere. Caymans.
You could use the USA. Wouldn't recommend the USA, but you
right, because of the problem that you cited. But okay, so stepping back here a little bit, how I want to get into like how people. Well, first of all, how much does it cost to set up one of these structures?
Give me the lawyer answer. It depends, right? But it like with any trust planning, for a trust to work, it has to own the assets that you're asking it to administer, or in my case, the assets you're asking it to protect. So if someone walks in with $10 million cash in one account, getting the trust funded is easy. I got to move one account. If someone walks in with $10 million, but they have 10 $1 million accounts, well, now I have 10 times the work to do to move the accounts. So it depends on what I'm doing. It depends on what the assets are. It depends on a lot of things. I am not going to look to someone's bottom line. I like to think that attorneys don't do that, but I suspect some do. This guy can afford more than that guy.
Right. You try to protect $1 million, you try to protect $10 million.
But that's where it goes. It goes to more the effort and the risk from the point of view that from my point of view. it's not inexpensive. I'd say on a low end, depending on what we do, you're looking to spend minimum 10 to 15, but typically it's probably 20 to 30.
10 to $15,000 and then
Yeah,
typically 20 to
yeah.
$30,000. Okay.
But it,
And
but it depends, and there are different things we can do, and it's another one of those things where how much protection do you want? Do you want 80% protected for $10,000? You want 100% for 30,000? So is it worth three times to buy yourself? You know, that sort of thing.
right. So if you set up one that has both Nevis and the Cook Islands in the structure, that's going to be more than just pure Cook Islands or pure Nevis or
Maybe, but honestly, from the point of view of what I have to do, it's the same. I've got to send, I do my work. I draft the actual documents that make up the structure. And then you're basically hiring a fiduciary and they have their own onboarding process.
right.
They do their thing. And believe it or not, and people, and this is a good time to bring this up. People hear offshore and they immediately get visions of some pirate kind of outlaw stuff.
Yeah.
And it is absolutely not that. These fiduciaries in both Cook Islands, Nevis, and most of the traditional offshore jurisdictions. And I'm not going to lie to you and tell you that there wasn't a time where they were pretty much the Wild West. It is not that way anymore. They
Okay.
are regulated. They are professional. They
Yeah.
are insured. They are bonded. The regulators in these jurisdictions have teeth. If you came in and said, Craig, I need an LLC and I want to set it up in Nevis, it's going to take a little bit of time. The people in Nevis are going to ask, all right, who is this Chris Mays? What do we know about him? And they're going to run a background check on you. And they're going to make sure you're not a member of Al Qaeda. And they're going to make sure you're not a gun runner.
Right.
And they're going to, when you tell them, and they're going to ask, what are you going to put in this LLC? What are you going to do with it? We're going to use it to hold securities and we're going to fund it with $1 million worth of securities. Okay. Where'd that $1 million come from? How do you earn it? They're going to ask these questions. Where if you told me that you wanted an LLC in California, I could do it before we're done with this call right here at this computer.
Right.
So it is absolutely positively completely above board. They are taking huge steps to keep the criminal element out. Money laundering, you hear the AML, CFT, and in your world, I'm sure those are terms you're familiar with.
Yeah.
Anti-money laundering, counter-financing of terrorism, they take extraordinary steps to make sure that they're not.
Well, yeah, because that's the sovereign risk issue, right?
Yep.
If to the extent you're financing terrorist groups, you always have the fear that you could it's like Panama. I mean, for a different instance, but there's a sovereign put. Effectively, the U.S. military came down there because they wanted to keep the canal open. Noriega wasn't complying. I
By the
can
way,
see that.
Panama is another jurisdiction that holds itself out as doing creditor protection. It's a relatively new statute and a new industry, and it's not extraordinarily well run. I don't use them. I've had a couple of clients come to me who had set up Panama structures and they had problems with their money, got stuck in a bank down there. Didn't lose it. They didn't lose their money, but the banks they were using had lost their U.S. correspondent banks, so they couldn't convert into USD and they couldn't move money in and out of the U.S. So it's things like that. So you need to be careful about what jurisdiction you use. And the Cook Islands and Nevis are both rock solid in that respect.
That highlights it. I mean, you really need somebody like yourself who knows how to navigate all the idiosyncrasies, because that's like the inside baseball story of, oh yeah, but your assets could get stuck in this bank because they've got these other problems. So in terms of like so if you were okay, so we kind of focused mostly on fungible types of asset, stocks, bonds, securities in general, cash. For real estate, like in assuming that you're not in one of the homestead, Florida or Texas, like is it possible to get really good protection around those assets?
Absolutely. Yeah. So what I would typically look to first is going back to this concept of exemption. So beyond the homestead exemptions, different states offer different things in terms of exemption protection. So here in California, we have a little statute kind of buried in the Code of Civil Procedure, 704.115. It is basically it's a private retirement trust. So it's not an ERISA retirement trust. It's enabled by California statute, and it comes from the public policy that the state wants people to be able to finance their own retirement. So we can set up one of these retirement trusts and we can put a real property portfolio in it.
Yeah.
And what that does is things that are financed into this trust, and to clarify what an exemption is, every state says you get a judgment in our courts. There are certain assets you can use to satisfy the judgment and certain assets you can't. So what we want to do is we want to move assets from the column of assets where you can use them to
Right.
judgment to the column where you can't. And that's what this private retirement trust does. So if we earmark certain assets as set aside for your retirement, they become protected. So that's a good way to do it. Another thing that I would look at is a non-self-settled trust. So we'd take a trust that maybe you set up for the benefit of your children, and you can gift your real estate portfolio into it. And now it becomes a much better case of, no, you can't have these assets because they're not mine. They belong to this trust. And then when the judge says, all right, who set up the trust? I did. That's not good. Who's the beneficiary of the trust? Not me. You win that argument. So even in a state like California, you can use a vehicle like that to pretty effectively real property. And then the other thing we talked about, it was deploying debt.
Right. Right.
If you have a mortgage, you're okay. It can be as simple if you qualify, maybe.
Could you set up a mortgage in the Cook Islands?
Yeah. No, there was a technique where that was being done. They called it a.
You've got a liability on a piece of property in the U.S., but held by a trust in the Cook.
If someone rips the lid off of that, they'll probably disregard that. Where people assert liens against their own property with some foreign that. Yeah. I like that. But if you get a legitimate debt from a real bank, boy, nobody can end run that. Sometimes it's as simple as a home equity line of credit or a reverse mortgage you can use to lean up your own house. I like to use a technique where we finance life insurance, and it's basically buying life insurance with borrowed money. So you're going to go to a bank and say, bank, I need to borrow money to pay a single premium life, or or pay premiums on a life insurance policy. Bank's going to go, boy, happy to lend you the money, but I need some security. Okay, well, how about this building with a ton of equity in it? Well, that'll work. And now you've got a cash value life insurance policy that's growing tax free, by the way. You've got a death benefit for your family that is ultimately going to pay the bank back. You've got an interest only loan, so you're getting a ton of coverage without taking a lot of money out of pocket. You're really leveraging
the cash value. Couldn't a court come after the cash value?
Yeah, absolutely can, which is why we put the cash value in an ILIT or a foreign trust.
Okay.
but absolutely.
Hey,
but that's another exemption, by the way. Different states have different levels of exemption for insurance policies, and California, it's not very high. I think it's around 16,000 is all. So if you've got cash value above that, it doesn't help you much.
So we're about out of time, but what I'd like to know is, like, do you have any crazy stories? Of course, we don't want to know any client names, but can you tell us any stories of instances where these asset protection?
Oh yeah, how many you want? Can I do two?
The most dramatic one would be probably the best for this conversation.
I got one where someone actually did try and go to the Cook Islands to challenge the fraudulent transfer, and I got one. Well, here, let's do this one. I got a client. He and his partner are real estate investors. They are an unincorporated association. There's a partnership. My client, or the guy who did the planning through actually this was at my old firm, who'd done the planning through us, didn't coordinate this deal that went south. His partner did. So his partner actually bought an unimproved lot, flipped it, and made a whole lot of money very quick. The seller saw that and got really mad. And the seller called him up and said, I just sold you this lot, and you turned around and sold it for 5-6 times what I sold it to you for. And my client's partner said, yeah. And, it wasn't a good deal for you, but it was what it was. I didn't force you to sell it to me. And there was some real animosity, and the seller ended up suing my guy. And because my guy is suing my guy's partner, and because they're partners, back to this concept, we drag everybody in. My guy gets dragged into this lawsuit. And somehow miraculously, and I was a litigator for years before I got into estate planning, still not sure how this happened, but it happens. When you go to trial, it's always a risk. Ends up getting a $64 million judgment, joint and
Oh my
several,
God.
against my client and his partner. Now they were both fairly wealthy guys, but they didn't have $64 million.
Right.
And the case, the trial was absolutely, it was stupid. I mean, I wasn't at the trial, but as someone who had done litigation, or even someone who's not, I could tell it didn't fully compute. So they wanted to file an appeal, and we're seeing this with Trump. It's big in the news. You
Yeah.
file an appeal, you always have to post a bond, always, always, always. And again,
Right.
the theory there is the court wants to make sure you're not just filing the appeal to delay.
Right.
The court wants, so what the court says is you put the money you owe this plaintiff in the court registry, you file your appeal, and if you lose it, we know they're going to get paid right away.
Right.
Typically, that bond, unlike in Trump's case, where it was one time, but my experience has always been at least 1.5 times. So there's a $64 million judgment against these guys. Court sets the bond at over $90 million. So they cannot get a bond for $90 million. And the plaintiff was not the least bit interested in talking any kind of settlement because of this animosity. They really hated each other. So the plaintiff comes after these guys really hard and is doing everything he can do to collect the judgment because they couldn't post the bond.
Right.
So while they're pursuing the appeal, if you don't post the bond, you can still execute your judgment. That's exactly what Donald Trump was just potentially facing before yesterday. The structure held up. They came after it hard. It held up. My guy stayed liquid enough to be able to pay his attorneys to pursue the appeal, which they appealed it. The trial court looked at it and said, what's going on here? The appellate court looked at it. They sent it back to the trial court, retried the whole thing, get a complete defendant's verdict.
Okay.
180 degrees. They went from owing $64 million to owing zero. If my guy didn't stay liquid, he couldn't have financed the appeal and probably would have ended up in bankruptcy. So they work, and this was a good case where it's the tort system out of control. You know, some people may look at these things and go, well, you're helping people not pay legitimate bills. Well, that's not what they're for.
Yeah.
They're there to give the defendant some pushback. Look, I don't. There is value in not having open judgments hanging over your head. You know what these things do is they help you settle the case.
Yeah.
If I get sued today by you and I go, Chris, I've got this thing. It's before we spend a lot of time on this. I want you to know what you're butting heads against here. You may very well say, all right, let's talk settlement. I don't want to mess with that, or there's not much value in messing with it. Right. So that's usually what happens. But in the case I just described, this plaintiff was angry. He'd have nothing to do with that. And he ended up with zero. And by the way, that litigation took over 6 years. Well, I think he had about $900,000 in attorney's fees, but $900,000 is a lot better than $64
million. But the whole thing, that second trial could have gone either way.
Yep.
Right. So the fact that and was this the Cook Island structure?
It was.
Okay. Yeah. Right. Okay. Yeah. So interesting. For $30,000 or $40,000 or even $100,000 to get that kind of protection, you know, just seems like it makes a lot of sense, because you're right. There's a lot of frivolous.
I am certain this client considered it money well spent.
Yeah. Yeah. Hey, well, I want to thank you. This was super enlightening, and you know, I feel like it's a area of the family office practice that we run that we don't, you know, we have some clients that are very interested in it, you know, and probably would benefit. I have had a client that did have a structure and it was successful for them. So, you know, I'm glad you were able to come on this podcast and tell us a little bit about your experience and some of the techniques that individuals can use to help protect themselves.